Good afternoon, everybody. Thanks for joining us for the second webinar in ConMoSCL-Carey's 2018 OSHA webinar series. I'm delighted to be joined today by my new partner in our new Chicago office, Aaron Gelb, and to be talking about a really interesting topic, the Lockout Tagout standard, OSHA's energy control standard. And this is one that we get tons of questions about, cases that we are often involved in, cases involving willful and repeat violations, criminal investigations, severe violator cases. This is one of these hot topics that we get that garners a lot of our attention, and I'm sure a lot of your attention as well. So thanks everybody for dialing in today, and we're looking forward to a very interesting discussion. The first voice that you're hearing, the faceless voice that you're hearing right now, is Eric Kahn. I'm the chair of ConMoSCL-Carey's OSHA Workplace Safety Practice Group. My practice for the last 18 years has focused essentially exclusively on occupational safety and health law issues. I work with employers through inspections, investigations, and enforcement actions involving OSHA and all of the other alphabet soup of agencies that get involved in regulating or investigating workplace safety incidents or compliance issues. I've handled a full range of OSHA litigation, from appeals of OSHA citations to criminal investigations and prosecutions. And as I'm doing today, I speak and write frequently on safety and health issues. I also work with my clients proactively to develop compliance safety and health programs, to audit safety and health programs, and to conduct training for employees and managers on safety and health compliance issues. As I said, I'm delighted to be joined today by my new partner, Aaron Gelb. I'll let him introduce himself to this group for the first time.
Thank you, Eric, and it's a pleasure to be part of the team. I've been practicing law for about 23 years now, about 12 years on the OSHA side. My practice is split pretty evenly between employment discrimination, harassment, and OSHA, with a pretty extensive focus on lockout, tagout, and other issues here in the Midwest and other parts of the country.
All right, and as I said, our program today is all about lockout, tagout. We've split it into really two categories. The first is, why is it important to get lockout, tagout right? What are the potential consequences if you don't get LOTO right? And then we'll move on to common mistakes that employers make, really not just employers, but common mistakes that are made by employers, by OSHA inspectors, by attorneys in OSHA solicitor's office, and sometimes by judges at the OSHA Review Commission. So this is a critically important standard, but a standard that is often confused and bungled by those who are out to apply it correctly. So let's talk a little bit about the first step of this is, why is it critical to get lockout, tagout right? First thing I would say about this is that it is just year in, year out, one of the most frequently cited standards in the OSHA portfolio of standards. You see this list every year, the top 10 list, and it rarely changes other than the order that things are cited in. But year in, year out, lockout, tagout is cited as one of the top 5 most frequently cited OSHA standards. Sometimes it's 3, sometimes it's 4, sometimes it's 5, but it's always up there in that top list of cited standards. So we know that it's something that OSHA's paying attention to. You hear this top 10 list referred to as kind of the low-hanging fruit, that when OSHA's in your facility, no matter what it is that caused them to be there in the facility, it's something that they can find and cite fairly easily. And so they do, and that's why it is year in, year out, one of the top 5 most frequently cited standards. So it's important to get it right because we know OSHA's looking for it, we know that they're citing it frequently, and you don't want to be on that list. The other reason why it's critically important to get it right, and frankly one of the reasons why it is regularly in the top 5 of frequently cited standards, is that there is an active national emphasis program that is really targeted on compliance with OSHA's lockout, tagout standard. Since about 2006, during the Obama administration, an Amputations National Emphasis Program was launched. And the purpose of that National Emphasis Program was to find and cite violations of OSHA's Lockout Tagout standard and OSHA's machine guarding standard. And I often look at these two sort of categories or buckets of standards as operating hand in hand. Where Lockout Tagout ends, machine guarding starts, and where machine guarding ends, Lockout Tagout starts. And that is because you've got your Lockout Tagout is to protect employees from hazardous energy, from moving parts, from the things that are dangerous about the machines and equipment that we work with in our workplaces when you are performing service and maintenance. And that's sort of the barrier is service and maintenance. Now, on the other side of that transom is normal operations, and that's where machine guarding kicks in. The machine guarding during normal operations is intended to protect you from that same hazardous energy, moving parts, and the things that make our machines and equipment hazardous, potential finger amputations, getting pulled into a machine, getting shocked by a machine. When you're engaged in operations, the machine obviously has to be active, live energy, and operating. Guarding needs to be in place to protect you. When you are servicing the machine, OSHA's expectation is that you're going to have that machine de-energized and locked out so that you're not exposed to the moving parts, the electrical shock, and the hazardous energy. So that's what this emphasis program is all about, is finding those areas where we're not protecting employees from the hazards of the machines that we work with, either in service or in normal operations. Has this been an effective enforcement program? You bet it has. Here's some data just from fiscal year 2017. 1 year alone, OSHA conducted almost 3,600 inspections. This is just federal OSHA, by the way. Almost 3,600 inspections under this National Emphasis Program. That's more than 10% of the total inspections that OSHA conducted, period, were done under this National Emphasis Program, looking for violations of Lockout, Tagout, and machine guarding. Over 2,700 of those inspections were done in the field of manufacturing, and about 1,200 of those inspections were triggered by, these were not programmed inspections, but in fact were triggered by incidents that were reported to OSHA. And remember, the new reporting rule requires you to report hospitalization of a single employee and any amputation, including fingertip amputations, which is often the trigger for a report to OSHA, which in turn triggers a National Emphasis Program, Amputations National Emphasis Program inspection. And one of the things, if you look at OSHA's policy about when they're going to conduct inspections after you pick up the phone and call them to report one of those injuries, there's all sorts of different qualifiers that, depending on how many people were injured, depending on the type of injury, what caused the injury, the history of the employer, you may get what's called a rapid response investigation letter, where OSHA doesn't do an inspection. They just write to you and say, hey, can you send us the results of your investigation and what you're doing to address the hazard? Well, if you're calling to report an amputation, the policy essentially says mandatory inspection is going to follow that. We've seen some circumstances where the circumstances of the amputation were obvious enough and not sort of high level enough to warrant an on-site inspection by OSHA, but technically by their policy, if you're reporting an amputation injury, they are supposed to come out and do an on-site inspection, and you can see that more than 1,000 inspections were done because of those reports in a program that has resulted in more than 10% of OSHA's total inspection program. 2,800 of those inspections that were done under this program, of these 3,500, 2,800 resulted in citations. And that's not terribly surprising if you think back on the percentage that I report every year of just overall OSHA inspections that result in at least one citation. I think it's about 75% of all inspections result in at least one citation. It would be no different under this program here as well. And then almost all of those, about 2,500 of those 2,800 inspections that resulted in citations were at least serious, so serious, willful, or repeat. Now, this is a combination of machine guarding violations, lockout, tagout violations, and perhaps something else random that OSHA uncovered in plain view while they were there as a result of this emphasis program inspection. But we do know, sort of anecdotally and from talking with our friends at the agency, that almost all of these citations are guarding or lockout, tagout citations. These 2,800 inspections resulted in citations. We've seen almost 8,000 total citation items issued under this emphasis program. And again, this is just federal OSHA, just in fiscal year 2017. So that's about an average of 3 citations per inspection that resulted in citations. The sort of more significant number to me is that of these 7,800 total citation items issued, over 300 of those were characterized as willful or repeat. And I think everybody on this call probably knows, but citations carry penalties for other than serious and serious violations up to now about $13,000 per violation. For willful and repeat violations, that's up to now a maximum of about $130,000 per willful or repeat violation, and we're seeing hundreds of willful and repeat violations being issued under this national emphasis program. And then a total of, you got to break this down by, inspections and violations, but a total of $55 million in civil penalties being issued by OSHA to employers under this emphasis program, just to sort of bring home why it is critically important to get this right, to do lockout, tagout right, because that OSHA is finding and citing these violations, and they're finding and citing them as willful and repeat at a pretty high level. Another reason why it's important to get LOTO right is that LOTO tends to feed employers more often than most other standards into the dreaded Severe Violator Enforcement Program. I think we've got a full webinar just on the SVEP program later in the year, but just to give you a little bit of a highlight as to why this is particularly relevant to your compliance with the lockout tagout standard is that one of the 4 categories that qualifies employers into the Severe Violator Enforcement Program is being alleged to have committed 2 or more willful or repeat or failure to abate, but really the focus, 2 or more willful or repeat violations related to a high emphasis hazard. And high emphasis hazards is a discrete list of specific hazards that OSHA is focused on, and amputations is one of those hazards. And I highlight this as being a particular risk because that particular category of how you qualify into the Severe Violator Enforcement Program happens to make up about 70% of all the SVEP cases that are out there. The employers that are really tripping up and falling into the SVEP program are getting in there because of 2 or more willful or repeat violations related to a high emphasis hazard, and there's only these 9 high emphasis hazards, and one of them is amputations. And we know that amputations are on OSHA's radar because they're doing about 3,500 inspections every year for this program, focused specifically on amputations. They're issuing thousands of LOTO or machine guarding violations, many of them characterized as willful or repeat, and that is how employers are getting into this dreaded Severe Violator Enforcement Program. And once you're in the program, I won't waste a lot of time on the program because we're going to go into depth on this later in the year. But it is bad news if you're in this program. You've got mandatory follow-up inspections from OSHA. Worse than that, if you've got multiple facilities, OSHA could be out there at as many as 10 or all of your sister facilities, related facilities, if you're qualified into this program. You get in, like I said, by alleged violations, and once you're in the program, even though it's by allegations, OSHA holds you to different standards, even in the settlement discussions with that very enforcement action, and we're seeing almost all of the settlements in SVEP cases involving corporate-wide abatement requirements, mandatory third-party audits, and all sorts of other onerous abatement provisions. And then a really, really heavy dose of public shaming. There is basically a bad actors list, the SVEP list, published on OSHA's website, and every one of these SVEP cases carries with it a nasty enforcement press release that dubs you as a severe violator that gets picked up by local and national media. And it's also one of these programs that, in my view, is essentially impossible to get out of once you get into it. So really, really important that you get lockout, tagout right to avoid that. And the last thing I would say about why it's important to get LOTO right is that it makes up a significant percentage, from my view, either the second or third. There's not a good data list out there, but I pay attention to these things, and it appears to me the lockout, tagout is either the second or third most common OSHA violation that supports a criminal prosecution out there at the state or federal prosecutorial level. You see most often trenching is the one that seems to create the most criminal cases, and then you see falls and lockout tagout as either the second or third most common OSHA violation that supports a criminal prosecution. Here's a couple of examples that we've seen recently. One in Illinois, where an employee was clearing out the discharge pit of a shredder, a large, industrial shredding machine, when his arm got caught in the conveyor, dragged him into the shredder and killed him. OSHA issued $520,000 in civil fines. There was $350,000 in criminal restitution paid out to the estate, and the company, this was a corporate prosecution, was put on 5 years probation with onerous terms about OSHA compliance and other forms of conduct that if they didn't meet that, there would be other criminal consequences as well. Another fairly famous case out in California involving an employee who entered a pressure cooker to perform maintenance, a large pressure cooker device for industrial volume of cooking of a tuna product. While he was inside performing maintenance, without lockout tagout, another employee, without knowing the employee was in there, started up the machine, began the cooking process, and essentially cooked his coworker. This case involved a very large plea and global settlement outcome where $3 million were earmarked to replace outdated ovens, $1.5 million in criminal restitution paid to the family of the worker who was killed, $750,000 in fines, another $750,000 to California's Environmental Enforcement Fund, and on top of that, there was personal liability for a couple of managers at the company. The safety manager pled to a felony conviction with 3 years probation and a $19,000 personal fine, and the operations director for the company pled to a misdemeanor crime, had a few hundred hours of community service, and an $11,000 criminal fine. So all of this is to say LOTO is important. If it's not one of your highest priority compliance items right now, it ought to be, and you ought to be really digging in to make sure you understand the nuances of the standard, you're complying, you're auditing your employees to make sure it's being done correctly, and you're getting help if you're not 100% sure that your program is up to snuff. So I'm going to turn it over to Aaron to talk a little bit about, we've talked about why it's important. He'll talk a little bit now about why employers are getting it wrong so often.
Thanks, Eric. And clearly, I think any time we mention criminal sanctions and the repeat monetary sanctions, it's pretty clear that there's a lot at stake when it comes to ensuring compliance with the standard. Unfortunately, it is a rather confusing standard, as Eric said, that trips up not only employers, but those within the agency that enforces the standard, the judges at the commission, and otherwise fairly sophisticated folks. So we're going to focus now on the 5 most common types of mistakes, at least according to OSHA citation statistics. And as you can see from chart, Eric, if you could, I'm having trouble advancing the slide, sorry. Thank you. As you can see from the chart on slide 14, the runaway winner involves machine-specific procedures with nearly twice as many citations as the second most commonly cited violation, periodic inspections. As you might expect, failing to establish a program is a commonly cited violation, presumably for those employers that do not realize that the standard applies to them. And that's something that we're going to discuss momentarily as far as the scope of the standard and when it does actually apply. The 4th most common violation involves not providing the required training which often includes forgetting to include certain groups or individuals in the training regimen that you've got in place. Last but not least, and I think this is interesting, the fifth most common violation, or should I say alleged violation, involves applying or carrying out lockout itself, which tells me at least that if employers get it right, or are getting it right with respect to the procedures, the training, and inspections, they're more likely going to be applying lockout correctly. So let's dig into the mistakes and start with the scope of the standard and the covered activities. So we're now on slide 16. Simply put, the Lockout Tagout standard applies to general industry workers performing servicing and/or maintenance on machines or equipment and who are exposed to the unexpected energization, startup, or release of hazardous energy. So let's unpack that sentence. First, the standard applies to general industry. That means it does not apply to employees who are engaged in a project covered by the construction standards or certain specialized industries. So assuming we're within the general industry, second, the employee must be performing servicing and/or maintenance, meaning some activity that is not part of the employee's regular duties, operating the machine for which he or she is normally responsible. So that can involve installing, setting up, adjusting, inspecting, modifying, maintaining, or servicing those machines or equipment. It can include lubrication, cleaning, unjamming, obviously something which is pretty common with many machines, making adjustments or tool changes. Third, the energization must be unexpected. If the employee has forewarning, he or she knows that it's coming or it's intended, then the standard won't apply. Keep in mind that the term unexpected also covers situations in which servicing and/or maintenance is performed during ongoing normal production operations if, this is important, if the employee is required to remove or bypass machine guards or other safety devices, or if the employee is required to place any part of his or her body into a point of operation or into an area on a machine or piece of equipment where work is performed, or into the danger zone associated with the machine's operation. Meanwhile, the standard will not apply to servicing and/or maintenance of equipment performed during normal operations if the safeguarding provisions, Eric talked about this a little bit before, machine guarding, and other applicable general industry standards are effective in preventing exposure to the hazards. So this is important, yet it's something, again, interestingly, that even we find in our experience that many of the folks, not many I should say, some folks at OSHA don't understand. You cannot have the same conduct cited as both a violation of the Lockout Tagout standard and the machine guarding standard. It's either one or the other. In other words, you can't simultaneously violate both standards. So if you get a citation that makes that assertion or that allegation, that's something obviously that you're going to want to challenge. Likewise, the standard does not apply to minor tool changes and adjustments and other minor servicing activities that take place during normal operations, which are routine, repetitive, and integral to the use of that production equipment, as long as the workers are effectively protected by alternative measures which provide effective machine safeguarding protection. This is, which I'm sure many of you are familiar, the minor servicing exception, which Eric is going to discuss in more detail shortly. Moving on to the next slide, there is a tendency to focus on hazards.
One thing I would add on that sort of that dividing line between construction and general industry service and maintenance. A good question about that has just come in. Is the same activity could be seen as both general industry service and maintenance and construction, and it depends on the context of the work being done. For example, installing or setting up a new machine, OSHA very clearly in its definition says installing and setting up is considered or can be considered a general industry service and maintenance activity. So I would view that as if it is an independent, sort of the only thing going on is installing that one machine, that is probably going to be viewed as general industry activity. If it's, an otherwise functioning factory, one new machine is coming in and you're in the process of setting it up, OSHA is going to expect that you're following the general industry lockout standard. However, if that is say a brand new factory where 100 new machines are going in and it hasn't been turned over to operations yet for any sort of function at all, and it is still the construction crew and your trade craft that are involved in the work activity, I think there is a very strong argument to be made that that activity is construction, and it's not covered by OSHA's general industry lockout standard at all. And if you look over on the construction side, unlike a lot of the other standards out there, there is not a very good partner or corollary lockout tagout standard on the construction side. There is a construction lockout standard, but it is limited really to just work on electrical circuits. So it is a totally different ballgame in terms of energy control if the project is considered construction. And it could be, and the analysis, if you look at the cases under the Review Commission, the analysis focuses on the overall scope of the project, how long it is expected to last in duration, the capital investment involved, the trades that are involved, and how much overall work is being performed at the time. And we see that confusion made by, OSHA compliance officers and area officers all the time, and it's something that is, it warrants careful analysis on a case-by-case basis.
Thanks, Eric. There's a tendency, and you mentioned electricity, to focus on the hazards posed by electricity. We're disconnecting the machine from the main power source so nobody is electrocuted. Obviously, that's a major focus. But while electrical energy is critically important, employers quite often forget or overlook the fact that the standard applies to a number of different types of hazardous energies beyond electrical. They can be present when an employee is performing servicing and or maintenance of machines, and that includes mechanical energy, hydraulic energy, pneumatic energy. So if you've got a piece of equipment that is connected to air hose or derives some power or operational function from the introduction of air, chemical energy, obviously Eric just mentioned the bumblebee tuna case, thermal energy. So if you've got employees that are entering ovens or other hot areas, you need to build into the procedures that you develop for this to comply with the standard time to allow that heat energy to dissipate before the employee begins the servicing or maintenance. Even in something, and this maybe is getting back to our high school physics days that some of us may prefer to forget, but springs, the energy that's inherent in a spring when it's compressed. For those of you that have power presses and do die changes, gravity is obviously a type of stored energy that can present a significant hazard. So quite often there will be multiple types of stored energy present even after the electrical energy has been isolated or removed. And there must be a procedure for addressing each type of energy. Last but not least, let's talk a little bit about some of the other standards. So this means even if you are mastering 1910-147, it doesn't mean that you have all of your hazardous energy control bases covered. There are a host of other standards that have their own unique, nuanced energy control requirements above and beyond this standard. So if you have permit-required confined spaces, those require lockout, tagout before your employees enter certain spaces, even if they are not going to be performing any sort of service or maintenance in that space or on the equipment that you're locking out. The grain standard has similar requirements before entry into grain bins, and there are heightened energy control requirements when working directly on electrical equipment, not to mention numerous other industries that have their own energy control requirements. So I think, Eric, I'll turn it back to you to talk about some potential significant changes to the standard.
You know what? I'm sorry I had you on mute, and I was making a bunch of really great points there. So let me start that over. Going back to, Aaron made the point that LOTO doesn't apply to unexpected energization, meaning if energization is expected, then you don't have to lock and tag out the equipment, or if you get a forewarning about the energization that's about to happen, you don't have to lock and tag out the equipment. And I just wanted to emphasize a couple things about that. First, which I find very interesting, is if you go back and you look at the original standard as written on OSHA's website, if you look at the listing of the standards and read the language of the standard in the CFR and in probably every book that you've purchased on that has the standards listed, the word unexpected is in italics. And I'm told, and I haven't gone back and done this check myself, but it is the only word in the entire, CFR from a, listing of OSHA standards. It is the only word that is italicized. And things are italicized, as you know, to emphasize them. So the word unexpected not only is present in the standard, it is the most emphasized term in all of the OSHA standards and the entire catalog of standards. Yet, OSHA historically ignored the word and pretended like it wasn't there, and they're undertaking a process right now to write it out of the standard. So there is a rulemaking presently. In fact, it is the only rule that in the Trump regulatory agenda has been moved to the final rule stage of the rulemaking process that would basically cut that word unexpected right out of the standard. And so let's talk a little bit about what that means and why they're doing that. Aaron, if your computer or phone you could be muted, that would be helpful.
Sure.
So the LOTO unexpected energization, what does this mean? For many, many years, OSHA interpreted LOTO to apply anytime there was energy that could harm an employee if a piece of equipment became energized. And so basically ignoring the word unexpected. So if the machine started up and it could harm you, then LOTO applies, regardless of whether the energy or the startup is expected or even intended. The Sixth Circuit, in a case that contested this, disagreed with OSHA and said, we're sorry, OSHA, but the language of the standard unambiguously renders lockout tagout inapplicable where an employee is alerted or warned that a machine is about to activate. And the court went on to say that a service employee, the standard only applies where the servicing employee is endangered by a machine that can start up without the employee's foreknowledge. And they went on to give some a list of factors to analyze here, and basically said that startup or energization is not unexpected if the machine alarms and gives a clear, audible, timely warning that the machine is about to start up. Energy is not unexpected if the controls are located in such a manner that the person who's performing the service is necessarily aware that startup is about to occur. In other words, if the on-off button is right next to his hip where he's sitting and performing service or maintenance, and there's no way that someone could come up and hit the start button without him being aware of it, that's not unexpected energization. And finally, if the equipment is unplugged, and the plug is in the exclusive control of the servicer, or otherwise the mechanism that starts and stops the machine is exclusively in the control of the servicing employee, then startup can't be unexpected, and so you don't have to engage in lockout tagout. And for 20 years, that case was decided back in 1996. For 20 years, employers have relied on that interpretation, that the standard only applies to unexpected energization. And if you have bells and whistles and alarms that tell you it's about to start, you can perform service without lockout tagout. And if the controls are located or exclusively in the control of the employer, you don't have to lock out the machine to perform service in those circumstances. OSHA obviously hated that interpretation and have struggled with how to deal with that for the last 20 years, and they found a way. And the way is to use a standard called a rulemaking process called the Standards Improvement Project, which is really intended to address non-controversial minor language changes to clean up inconsistencies, to clean up typos, to clarify things where there's a lot of confusion. It is not intended, I would say, for a wholesale substantive change to a standard that has been clearly defined for the last 20 years, and which was the intent, I think, was clear from the beginning by use of the italicized word unexpected energization. But OSHA is using this SIP process, which is sort of a lightweight or easier rulemaking process than the more burdensome full APA lockout tagout process that should be used for substantive changes. And they've got that in the final rule stage. Obviously, that started during the Obama administration. The Trump administration is, technically in place, although not in place in great force at OSHA, still without an approved Trump-selected Assistant Secretary of Labor for OSHA. So it'll be interesting to see whether they follow through with this rulemaking. It has moved to the final rule stage, and we'll see what happens there. But OSHA is following this process, they say, to return the scope of LOTO to the original intent, which I dispute. They would not have written the word unexpected in there and put it in italics if they didn't originally intend it to mean exactly what the Sixth Circuit says it means. But they say they're doing this to ensure that LOTO is used instead of less effective warning systems, and they're doing this to reduce the burden on their compliance officers who need to perform a case-by-case assessment of warning schemes, which I would suggest they should be doing no matter what. They should always be doing a case-by-case assessment before issuing penalties and fines, but that's what's happening. So this is something that I'm tracking to determine whether OSHA is going to follow through and actually enforce that or finalize that rule. So I'm turning it back over to Aaron to talk about the second most common mistake that employers make.
Thanks, Eric. With a standard so complicated that it merits its own webinar, you might imagine that it has a training component and one that's not always applied correctly. So let's talk about first who needs to be trained. Obviously, all employees need to be trained so that they understand the purpose and function of the company's energy control program and acquire the knowledge and skills necessary for the safe application, usage, and removal of the energy controls that are going to be used. So Section 147C7 requires training for three types of employees: authorized employees, affected employees, and other employees whose work activities are or may be in an area where energy control procedures may be utilized. What we find, and the citation data backs this up, is that quite often employers are forgetting the latter two categories. I think it's easier to understand or grasp the fact that if someone is performing the servicing or maintenance that they are authorized to do, that they need to be trained accordingly. And where the ball tends to get dropped on occasion is training those affected and other employees. Just briefly to orient everyone, however, the training as far as what the standard requires for authorized employees is that each authorized employee receives training in the recognition of all potentially hazardous energy sources, the type and magnitude of energy in the workplace, and the methods and means necessary for them to isolate and control the energy that presents the hazard to them. So the employer has to provide training that will allow each authorized employee to understand the purpose and function of the employer's energy control program, and allows that each authorized employee to develop the skills and knowledge necessary to safely apply, use, and remove his or her lockout tagout device or its equivalent, and take other necessary steps so as to effectively isolate hazardous energy in every situation in which he or she is performing servicing or maintenance activities. So what about those affected employees and the other employees? They obviously need training too. The affected employees must receive training on the purpose and use of the energy control procedure. Meanwhile, other employees, the ones that we talked about, those that work in activities or maybe in an area where these control procedures may be utilized, must be instructed about the procedure and about the prohibition relating to attempts to restart or re-energizing machines or equipment that are locked out or tagged out. And I think, again, not to harp on Bumblebee Tuna, but that's a perfect, very serious example of when an employee may not understand or recognize that a piece of equipment should not be re-energized, obviously. And a note also, don't forget about your temporary workers. If you've been attending or listening to CMC webinars, you've probably heard us talk about the temporary worker initiative. If you utilize temporary workers and you're exposing them to hazards, make sure that they are given the same training as your regular employees are exposed to those hazards. Do not rely or assume that the agency that sent those individuals to you has fully trained them. Indeed, that you as the host employer have knowledge of the hazards in such that the agency is likely or certainly is not going to have. And Eric talked about the questions that you're going to be asked if you report an amputation or hospitalization. You can bet one of the first questions that a COSHO is going to ask after an accident is whether the injured individual was a temporary worker. And so the next step is they're going to be asking you about the training that he or she has received. Also, just quickly a note, don't forget to retrain your employees. Similar to the powered industrial truck standard, there are certain circumstances when retraining is required. So you need to be aware of what it is that triggers the need to retrain. A change in job assignments, a change in the machines or equipment or processes that you're using that presents a new hazard, a change in the energy control procedures that you're applying, and I'm going to be talking a little bit later about periodic inspections. If in the course of doing your periodic inspections it reveals that there are deviations in the energy control procedure, such that you believe that there are inadequacies in the employee's knowledge or use of the energy control procedures, ultimately your employees must possess the skills and knowledge necessary to understand all the relevant provisions of the energy control procedures in order to effectively isolate the sources of the hazardous energy to which they and others are going to be exposed. Another instance where employers forget to include someone is in training or other related issues is group lockout. Most employers don't have too much trouble ensuring that a lockout device is used when there's one person performing service and or maintenance. We've seen a lot of mistakes happening, however, when there's more than one authorized employee involved in the process. So when servicing or maintenance is being performed by a crew, a department, or other group, you as the employer need to ensure that they're going to utilize a procedure which affords the employee a level of all of the employees working on that project protection, a level of protection equivalent to that's provided by the implementation of a personal lockout or tagout device. In these situations, you have to assign overall control responsibility to an authorized employee and designated that person is going to coordinate the affected workforces and ensure a continuity of protection, at the same time requiring that each member of the crew affixes his or her own personal lock to a group or gang device. This is one of those areas where you'll greatly enhance your chances, in my view, of prevailing on an employee misconduct offense if your managers adopt a zero-tolerance approach and coach, counsel, and ultimately discipline employees who are found working as part of a group without affixing their own personal device. The last thing that you would want to have happen in the course of an inspection, or if you're talking to us after you've been cited and we're trying to develop those defenses, and it turns out that the managers, first-line supervisors have knowledge that employees are regularly working or performing servicing and maintenance in a group setting without everybody affixing their own device, and they don't take action, that's likely going to preclude you from raising that defense. We also see employers tripped up when they lack confidence in their crew and decide to handle lockout themselves. I like to think about it like a supervisor lockout. It's not a real concept, but you get the idea. It's really, in a way of, maybe I'd analogize it to parents who don't trust their kids to clean the house properly, so they do it themselves. Even if you know that you'll do it safer than your employees and that you're not going to allow anything to go wrong, you still need to make sure, even if you're overseeing this process, that each employee working on the project affixes their own personal lockout or tagout device. So we're going to change gears now, or die blocks, if you will, to talk about the most common lockout tagout citation machine-specific procedures. Having a program is not enough, clearly, from the citation statistics, if the employees don't have the separate procedures for each machine or class of machine. This is something that the COSHOs are specifically instructed to look for, documented procedures during their inspections. They're instructed to ask the employer for documentation, including procedures for the control of hazardous energy during these inspections. So what constitutes effective procedures. Having effective machine-specific procedures means that they're going to inform the workers not only what to lock out, but also how to lock it out in order to create safe working conditions. Procedures must be written in sufficient detail so that all steps for shutting down, isolating, blocking, securing, and relieving hazardous energy are clearly covered. In other words, the procedure becomes the checklist to ensure that all energy sources are controlled before servicing or maintenance starts. The procedures also have to identify the specific steps for placement, removal, and transfer of lockout tagout devices, as well as specific requirements for testing the equipment to verify it's in a zero energy state. Trend or not, I've seen several citations recently issued to clients who omitted the testing step from the procedures. If you stop and think about it, what good are the various steps prior to that if the employer is not making sure that the employees who are the authorized employees, that they've created the safe work conditions leading up to that point. So the procedures must be machine specific, meaning that an authorized employee can properly lock out the specific piece of equipment that they're working on by following these procedures. Now, OSHA would like employers to develop a specific, unique procedure for each and every piece of equipment. That, however, is not what the standard requires. More than one piece of equipment can share the same procedures if certain requirements are met. They have to have the same hazardous energy source, and they have to have the same or similar methods for controlling that energy. OSHA defines similar machines as those using the same type and magnitude of energy that have the same or similar types of control measures that can be covered by a single procedure. So an employer must develop, however, separate energy control procedures if their workplace has more variable conditions such as multiple energy sources, different power connections, or different control sequences that workers must follow to shut down various pieces of machinery. You can group the machines or processes by similar characteristics such as cord and plug, a single energy source, or types of energy, hydraulic, pneumatic, kinetic, thermal, chemical, etc., which can cause unexpected energization or startup of the machines. If you are using a group procedure for several similar machines, you may want to consider a node or inset that calls out a unique aspect of a certain piece of equipment. At the same time, due to the nature of certain equipment, some procedures may become very long and complex, so everything does not necessarily have to be treated in one procedure. Sub-procedures can be used to make a procedure simpler and shorter. For example, information such as instructions for locking out commonly used valves may also be included in sub-procedures. And while sub-procedures may simplify complex procedures, typically I recommend avoiding using too many sub-procedures that require the user to reference another document, because referencing too many different documents may wind up making the procedure even more complicated and make updating the procedure difficult. The key to sub-procedures is to make them as concise, as clear as possible while reducing the amount of information in the original procedure. I'd like to make a note about abatement. If you're in the process of settling a citation, obviously, hopefully you're talking to us about that, but under this section, you want to make sure that you need to develop machine-specific procedures for a number of pieces of equipment. Make sure that you build enough time in to develop all those procedures. It can be a time-consuming process, and sometimes I think employers are overly optimistic about how quickly they can get that done. So you want to really make sure you're setting realistic deadlines or agreeing to realistic deadlines yourself. If you do that and you still run out of time, be proactive. And consider submitting a petition to modify the abatement. Don't just cross your fingers and hope. There is a limited exception when documentation of procedures is not required. I'll run through that quickly. An employer does not have to document the required procedure for machine or equipment when all of the following elements exist, and that includes that the machine or equipment has no potential for stored or residual energy or reaccumulation of the stored energy after it's shut down, that it has a single energy source that can be readily identified and isolated, that the isolation and locking out of that energy source will completely de-energize and deactivate the machine, that the machine is isolated from the energy source and locked out during servicing or maintenance, that a single lockout device will achieve the lockout condition, That device, the lockout device, is under the exclusive control of the authorized employee performing the service or maintenance, that the servicing or maintenance does not create hazards for other employees. And this is important, the last piece, is that the employer has had no accidents involving the unexpected activation or re-energization of machines, these types of machines during equipment or servicing and maintenance. Now, shifting gears again, talk briefly about sharing procedures with contractors. Assuming you have the required procedures, let's talk about what you need to do with them when you have an outside contractor doing servicing or maintenance. If the outside contractor services or maintains machinery at your work site, the on-site employer and the contractor have to inform each other of their respective lockout or tagout procedures. You, as the on-site employer, must then ensure that your employees understand and will comply with all the requirements of the contractor's energy control program as well. We often get the question, though, or occasionally get the question, what if you contract out all of your service and maintenance operations? Well, you still need to have a program, but you do not need machine-specific procedures, or you don't necessarily need them, nor do you need to share them with the contractor. But there's a rub. You have to get it right, meaning that if you're relying on the minor servicing exception to cover certain tasks, you need to make sure that all of the elements of the exception are satisfied. And you need to make sure that your employees are not performing service or maintenance without your knowledge, sort of the wink nod of certain managers, because it's faster than waiting for the contractor to come. I think with that, Eric, I will turn it back over to you.
All right, so we're on to the fourth of the common mistakes that employers make, not just employers, but common mistakes that those stakeholders in the lockout-tagout process mistake, and that is understanding and applying the minor servicing exception that Aaron just referenced. So the minor servicing exception, what is it? It is an exception to the requirement to de-energize and lock out equipment for certain minor servicing activities, such as clearing jams, minor tool changes, minor equipment adjustments, if they meet certain requirements. And those requirements include that the task is performed during normal operations and the task is necessary to the production process. So if you think about clearing a package jam on a conveyor system, it is done during normal operations while the packages are flowing through the conveyance system. If they jam in the middle of that operation, it is necessary for the production process. If you don't clear the jam, nothing moves beyond that point on the conveyance system. It's done during normal operations because the process is still running and still operating unless you shut it off to clear the jam, which may be a part of your process. You could still do that without having to de-energize and lock out the equipment if it's during normal operations and it's necessary to the production process. Same for a tool change or a minor adjustment. You're in the middle of operations and you need to make an adjustment, need to make a tool change, and it is critical to the production process, integral to the production process. You've cleared step one of the application of the minor servicing exception. Step two is that the activity is routine, repetitive, and integral. And we're going to get into what that means specifically, but as a preview to that is there's not a very clear definition. I'll tell you what OSHA says about it, and I'll tell you what I think it means. And then finally, if it is an activity that is routine, repetitive, and integral to the production process, and it is done during normal operations, and it's necessary for production, then the last step to being able to rely on the minor servicing exception to lockout tagout without having to de-energize and lock out the equipment is that the worker is protected from hazardous energy by effective alternative measures. Also a loosely, poorly defined concept that we'll talk about in some more detail. So what does it mean for something to be routine, repetitive, and integral to the operation? Routine, and these are definitions that OSHA has offered in guidance documents. An activity is routine if it is a regular and prescribed course of procedure and performed in accordance with established practices. So it's not just about repetitive. The repetitive concept is maybe more about how frequently something is done. Routine is about how typical it is done. Is it always done and it's essentially the same way following some specific prescribed procedure or some specific prescribed practice. So taking the example of clearing the jam, if it is something that is done regularly the same way, using the same tool or the same practice, that would be considered a routine minor servicing activity. Repetitive is about sort of frequency. Is this something that is repeated regularly as part of the production process or cycle? Again, this is not, very well defined anywhere. And the one thing that I would just bring up, and I don't think we've mentioned this yet today, but it's important to understand about the lockout tagout procedure, is that it is a performance standard. And while it does have, 100 different subparts, which makes it feel like it's very specification-oriented and very, prescribed manner of compliance-oriented, it's not. It's a performance standard. The performance objective is effectively de-energizing and controlling hazardous energy. So I would apply that same concept of performance-oriented to this minor servicing exception. Repeated regularly means, whatever it means to the employer to effectively protect employees from the hazard. If it's something that happens, on a repeated basis once a week, I would say that is, that meets the criterion. A compliance officer might say, no, repeated means multiple times during each cycle, multiple times during each production run. There's nothing that defines that. There's nothing that says that. Repeated regularly as part of the production process means whatever it means to the employer within reason. And I think it's, it doesn't necessarily mean that it happens at the same exact time in every process. Taking the clearing the jam as the example, that's a little less predictable, I think, than making a tool change. You know that every time you make product X, halfway through the process, you need to make a tool change or you need to make an adjustment. That's repetitive and routine, just as clearing a jam is, although you can't say exactly halfway through, we're going to have a jam to clear. I just know that in, 75% of the times that we do a run, we have a jam. And it may be once or it may be twice or it may be 3 times, and I know that that's going to happen on some regular and frequent basis. That would be enough, I think, to demonstrate that the minor servicing exception applies. And then finally, that it's integral to the production process. It can't be that you're doing something that is really a servicing activity. I guess I should say really a reactive or breakdown maintenance activity. It has to be integral to the production process. And I think that is generally going to be, if it's routine and it's repetitive and it's happening during normal operations and you can't proceed with normal operations until you address that issue, then I think that you could, effectively assert that it is integral to the operation. That's sort of my view of it is, if but for taking this step, but for taking this minor servicing activity, I cannot continue with production, or production will be messed up. I'm going to make off-spec product, or I'm not going to make product at all, then it's integral to the production process. Finally, effective alternative measures. This is one of the criterion for the exception to apply. So it's not enough to say it is a minor servicing activity that is routine, repetitive, and integral to operations. You still would have to implement lockout tagout compliant with the requirements of 147 unless you can develop and implement an effective alternative measure. And this is an alternative to locking out the machine that is effective to protect employees from hazardous energy. So you must demonstrate that your LOTO substitute, whatever that protective measure is, provides effective protection from hazardous energy. I would assert that it is, one of the things you see in a lot of other OSHA standards is something must be equally effective or as effective. That term does not appear in the definition for minor servicing exception. What appears is the concept of effective, not necessarily as effective. That would be an argument I'm sure that you're going to have with the area office, but I think you would be on strong legal footing if you have demonstrated that your process is effective, even if it is not as effective as de-energizing and locking out the equipment. Some examples that OSHA gives of acceptable, effective alternative measures are measures that involve using a specially designed tool or a remote device. And here the concept is, you've got a device that allows you to reach into the machine using a rod instead of your hand or arm. To me, that's, really not even an exception to lockout tagout, because if you're not in the danger zone, you're not exposed to hazardous energy, lockout tagout wouldn't apply anyway, but these are some of the examples that OSHA gives. Similarly, relying on an interlocked barrier guard or a local disconnect or a local control switch, all of these things, if they're under the exclusive control of the employee performing the minor service, would be expressly approved by OSHA using the guidance they've given. I don't consider this to be an exhaustive or exclusive list. I don't consider that exclusive control concept to be mandatory under the law, because the law says something must be effective. And I think if you can demonstrate that your alternative measure is effective, even if some control is not under the exclusive control of the servicing employee, then you've met the requirements of the standard. OSHA may disagree. You may have a fight on your hand, but that is, the concept is that your alternative measure must be effective, and if you can demonstrate that it's effective, then you have satisfied this requirement. And effective means, to me, effective means you're protecting employees from the hazardous energy. So if you have a concept where you've engaged an emergency stop, and you station an employee at the emergency stop with a two-way radio with the other employee, OSHA would probably disagree and say, well, that's not under the exclusive control. It's true it's not under the exclusive control, but is the process effective? And similarly, if you build in forewarning and alerts like audible alarms and visual flashing lights in concert with a process where an employee guards the e-stop, and the e-stop fails safe if there is a circuitry problem, all of those things combined, and you can demonstrate we've been doing this once or twice a shift every day for the last 10 years without incident, and it is I think you've made out the case that it's an effective alternative measure. Now, OSHA may disagree with that, and you may have to take that before a judge, but it is a loosely defined concept. And effective, in my mind, effective means effective. Measures must enable the employee, and this is the ultimate performance goal, is whatever those measures are, they must enable the employee to safely perform minor servicing without being exposed to unexpected energization. So if you can demonstrate that the steps you've taken, whether it's engineering controls, administrative controls, or a combination of the two, if they effectively protect an employee from unexpected energization, I think you've met the requirements for an effective alternative measure. And we'll move on to the final of the 5 common LOTO mistakes.
Thank you, Eric. So finishing up with the periodic inspection requirement. Conducting periodic inspections sounds simple enough. It's sort of at least at first blush, and maybe something that's just a check the box. You make sure that your safety team has the dates calendared, the reminders on their Outlook or what have you, to make sure that these things are done, or they're using the software that reminds them to do that. As far as the timing of the periodic inspections or how often they need to be done, it's at least annually, and that's again usually something that most employers are getting right. Keep in mind, however, that if you've got procedures that are used less than once per year, then you need to make sure that they are inspected each time that those procedures are used. Mistakes you see a little bit more frequently are as far as who's conducting the periodic inspection. The periodic inspection has to be conducted by an authorized employee other than the one who implements the procedure. In other words, the authorized employee performing the inspection has to be they can be someone who has previously implemented the energy control procedures being inspected, as long as he or she is not implementing any part of that control procedure while it's being inspected. And now it need not be your employee. It can be a consultant who's hired to assist with the inspection process. As far as conducting periodic inspections, an authorized employee simply means a qualified person who has the authority and responsibility to perform a specific lockout or tagout inspection and has been given that authority by the employer. So how does that individual, whether it's your authorized employee or a consultant, how does that person go about their task? This designated person has to observe the implementation of the energy control procedures for the servicing and or maintenance activities being evaluated and talk with the employee implementing the procedure to determine that all the requirements of the Lockout Tagout standard are understood and are being followed by that employee. He or she must observe the procedure being implemented by a representative number of authorized employees and must talk with all the other authorized employees, even though they may not be implementing the energy control procedure. The next question is, what has to be inspected? Similar to what I talked about earlier with regards to machine-specific procedures, I think OSHA would prefer that employers inspect every procedure separately. That also is not necessarily required. As an employer, you're only required to perform periodic inspection on each unique energy control procedure that you utilize. In other words, an employer may group machines or equipment with a similar magnitude of hazardous energy and controls if all of the procedures in the proposed grouping have the same or similar intended machine use, same or similar procedural steps for shutting down, isolating, blocking, and securing the machine or equipment, the same procedural steps for placement, removal, and transfer of the Lockout Tagout device, and responsibility for those steps. And finally, the same requirements for testing to determine and verifying the effectiveness of the Lockout Tagout devices or other control measures. So it's really something that you have when you're making that determination. That it's really common sense, but a case-by-case assessment of figuring out whether these procedures can all be lumped together in the same periodic inspection, or if they're sufficiently different as far as any of those four criteria that you're going to need to conduct a separate inspection for a certain procedure. The grouping is acceptable as long as the inspection sampling reasonably reflects plant servicing and or maintenance operations and the hazardous energy control procedures for the procedure being inspected. Now, one common mistake that employers make, for each procedure, the inspector must also conduct a review with all the other authorized employees involved in implementing the energy control procedure to review that procedure and their responsibilities under it. If an employer's inspection protocol does not include a review of each separate procedure with all authorized employees who may have responsibilities under it, the protocol will fail to comply with the standard. Another mistake that some employers make is the use of group meetings to review the energy control procedures where implementation is not actually inspected. So the implementation of each separate lockout procedure must be observed by the inspector for a representative number of employees who implement that procedure. It goes without saying, of course, that the inspection must ensure that any deficiencies or deviations which are identified during the course of the inspection are corrected. And of course, don't forget to create a record that documents the machine that's been inspected, the date that the inspection has been done, the employees who were involved, and the inspector. I think obviously I often operate under the view that if it's not documented, and certainly this is I think a stance that many co-shows have taken, if it's not documented, it didn't happen. So Eric, I'll turn it back to you to wrap it up, or if we want to take questions.
Yeah, I mean, did you go through this, the concept of grouping of machines? I think you did, right?
Yeah.
Right. And I mean, just to reiterate this point, because this is the one that I think you see the most questions I get from employers is on machine-specific procedures and periodic inspections. Hey, we've got thousands and thousands of machines or hundreds of machines that are, by and large, grouped into 3 or 4 categories. Do I need to do a machine-specific procedure for 1,000 machines, or 4 different LOTO procedures for each category? Do I need to do a periodic inspection for 1,000 machines and 60 authorized employees, or just by category? And you are allowed to do them by category if they have the same or substantially similar control measures. You can do representative set of authorized employees But the key at the end of that process there is that if you're doing representative authorized employees rather than all of your authorized employees, you do have to review with all of your authorized employees the outcome of the annual inspection. So you can do representative machines and representative workers, but you have to make sure that they're truly representative and then review the outcome with all of your workers. So I just, at the end here, want to encourage everybody to join us for the rest of the webinars in our annual series. This is just the second of 12. We've got one coming up in March, and if you've been following along with this program for the last couple of years, you've seen that this particular one, OSHA's new leadership team, keeps getting moved because there really isn't much of a leadership team to report about. We may do that again here. We may just go ahead and do the program based on the folks that have been nominated and the rumors of who's going to fill other posts, so we can just stop changing this month after month. But I'd encourage everyone to sign up for all of the remaining programs. You can just send an email and request to be automatically signed up to all of them, and we'll take care of that. I'd also encourage everyone to check out our blog, the OSHA Defense Report blog, www.oshadefensereport.com. We got all kinds of breaking OSHA news up there and really in-depth analysis. One of the things that we pride ourselves on our blog is it's not just OSHA issued a new letter, here it is. OSHA's got a new program, here's a link to it. We actually analyze what these things mean to you and how they might affect you. So I'd encourage everyone to check that out if you get a chance. Now we'll turn real quickly to a couple of questions that came in during the program. There is a good one here about, I think I addressed the one about installing machines. Here's a good one that says, if machinery or equipment is in a jog mode or a safe run mode for adjustments, lubricating, cleaning, etc., are you required to LOTO the equipment? This is going to implicate a couple of different things that we talked about today. One is this a minor servicing activity? It sounds like it probably is, depending on how integral it is to production operations, how routine and repetitive it is. And it may be that your safe mode, perhaps in concert with some other administrative or engineering controls, meets the effective alternative measures element and allows you to rely on the minor servicing exception. So that would be one way that you wouldn't have to lock out for that activity, but you'd have to analyze on a case-by-case basis whether you meet all four of those criteria for the exception to apply. Another concept that you might be able to rely on is the concept under Lockout Tagout, under the standard, that allows for some live troubleshooting. If it meets the criteria for live troubleshooting, you might be able to rely on that if, likewise you follow a certain set of criteria, like clearing tools out of the way, clearing people out of the way, just doing enough of the jog mode, or just doing a little bit of the actively running the machine to observe what is wrong with it, and then going back into a lockout state. It doesn't sound like that's what you're describing there, but there is a process that allows you to do some live troubleshooting if you meet certain criteria. Otherwise, I would say that those activities are servicing activities and would implicate lockout tagout. So if you're not meeting all the criteria for minor servicing, lockout would apply, and simply running in a jog or safe run mode would not be sufficient. I think that would be, Aaron, do you have any different view on that, or is that consistent with your take?
No, in fact, we recently negotiated a settlement of a lockout citation. It sounds somewhat similar, where the employer needed to move the rolling cylinders in order to clean them, and we were able to negotiate an arrangement, kind of as you discussed, with the kind of additional protections to ensure that the person would since they would be close to the zone of danger, it was a kind of a two-part solution where first there was a device that the employee would use to apply the cleaning mechanism to the rollers while they were being advanced, that kept them directly out of the point of operation, but on top of that, that they would be standing on some sort of on a pressure mat, so that if they then left that area, that it would kill the power to that section. But I think the agency, at least in my experience, certainly recognizes, or at least the reasonable folks that we deal with, that there are going to be instances where you need power in order to accomplish something and cannot lock it out.
Another question here is, what does annually mean? I assume they were talking about the periodic inspection requirement that must be done at least annually. And that's a really good question, because there are standards out there that require you to do something once each calendar year or once every 12 months. And the difference, obviously, is you could do something in January of 2017 and then not again until December 2018. You've done it once each calendar year, but you're really, almost 24 full months apart. The answer to the question here for the periodic inspection is that it's every 12 months. So if you put yourself on a cycle where you're doing them in March of every year, you've got until March of the next calendar year to get it done again. And the other thing to keep in mind is that this is not a requirement that it is probably easier and conceptually a lot cleaner to do this kind of all at once for multiple authorized employees and multiple LOTO procedures that you're inspecting at the same time, but you're not required to do them all at the same time. You could do, a batch of them in the first quarter, another batch in the second quarter, another batch in the third quarter. You just need to make sure that that set of procedures that you've done is inspected again within 12 months of the last time you inspected that procedure. Or, as Aaron pointed out, if it's not a procedure that you're using every year, that you're doing the inspection of it before you utilize it again, if it's outside of that that annual process. So that's a really good question, and hopefully that addresses the question. The periodic inspection, there's a question here, does that require an authorized person? The answer is it requires at least 2 authorized persons. The inspection needs to be done by an authorized person, observing the implementation of the procedure by another authorized person. And that's a common mistake we see made, is that an employer may rely on the same person to say, all right, I'm going to go out and do an inspection of our LOTO procedures, and by myself I'm going to implement the procedure and check as I'm doing it that the procedure is current, effective, and being implemented correctly. The problem is you can't do it yourself. It needs to be done by an authorized person observing another authorized person implementing it. So an answer to the question, it requires at least 2, and both must be LOTO authorized people. I think that's what I've seen in questions. If I missed any, we'll look through them after the program, after I stop the recording, and I'll follow up by email if I see something we haven't addressed. I do want to thank everybody again for joining us. We did our best to keep it around an hour and 10 minutes and only missed by about 10 minutes. So we'll keep working on that. I appreciate everybody giving us so much of your time for these webinars, and for seeing a lot of the same names in the registration. I appreciate everybody coming back. That means we're not boring you to death, and you find this useful, and that's gratifying. So thanks again. We've recorded this webinar. We will be sending out a link to the recording and a copy of the slides to all of you. And as I say every time, if there's ever anything we can do to help, please don't hesitate to contact us, even if it's just to bounce ideas off us, share your own experiences and thoughts about some of these concepts. We're big OSHA nerds. We love hearing about it. We love talking about it. So please don't ever hesitate to contact us. Thanks again, and we'll see you next time.